In this lecture, we would like to discuss another piece of legislation enacted in 1974, and that is Conservation of Foreign Exchange Prevention of Smuggling Activities Act. As during the 60s and 70s, Indian economic and financial stability was broken due to war with China and Pakistan, and so also the increasing smuggling activities on the western part of India, exclusive the western coastal states of Maharashtra and Gujarat and Goa, where most of the smugglers involved, such as Haji Mastan, Karim Lal, Ishu Patel and etc., those who were carrying smuggling activities through seaports of Bombay and also from Goa and also from Gujarat, which completely weaken and unstable the economic system of India. And besides that, India was facing a large shortage of foreign exchange reserve. So, the then late Prime Minister, Mrs. Indira Gandhi, initiated the very bill in regards to conservation of foreign exchange and prevention of smuggling activities, and the Parliament of India enacted in 1974 the very act, and the very purpose of the act is to aims to prevent smuggling and ganja foreign exchange, and the very act applies to the entire country, and the act establishes a framework in regards to detention. So, for preventive detention, including specified grounds for detention, authorities to issue detention orders and an advisory board for review of such detention. So also it provided regarding judicial review. The Act includes provisions for judicial review to ensure due process and procedure established by law and to safeguard individuals' fundamental rights. So, also the very detention conditions. The Act specifies that the appropriate government, in regard to the power to regulate the place and conditions of detention and such detention order, as per the Act, the state government must report to the central government within 10 days of issuing detention order. The grounds for detention must be communicated to the detained person within 5 days or up to 15 days in exceptional circumstances. So, such piece of legislation, the very act, conservation of foreign exchange and prevention of smuggling activities act undoubtedly provides the very aim of preventing smuggling activities in India and also badly the need of preserving foreign exchange reserve and increasing foreign exchange reserve. So the very act also provided advisory boards under preventive detention laws and all other preventive laws regarding detention under such preventative laws. So the very Conservation of Foreign Exchange, Prevention of Smuggling Act 1974, which was passed by the Parliament of India, it enabled preventive detention in specific cases related to the conservation and augmentation of foreign exchange and to prevent smuggling activities and associated matters. It also provided power to make detention orders and also the central government, state government, or designated authorities such as a joint secretary of the central government and secretary of a state government can issue detention orders for individuals, including foreigners, in cases falling under the very scope and jurisdiction of the Act regarding smuggling activities or anyone assisting in such smuggling activities or involved in transporting, concealing, and storing all kinds of smuggled goods, and also anyone who is providing shelter to individuals involved in smuggling activities are also covered under the provisions of Conservation of Foreign Exchange and Prevention of Smuggling Act, and also those individuals or persons or entities dealing in such smuggled goods. And any detention order issued by the state government must be sent to the central government within 10 days. And the very grounds of detention, as provided under the Conservation of Foreign Exchange and Prevention of Smuggling Act of 1974, the reasons for detention must be communicated to the detained individual within 5 days. A delay up to 15 days is permissible if provided in writing. The detaining authority must satisfy both the courts and the detainee that the detention was carried out in accordance with the law and after due consideration. The Act also provides the jurisdiction of high courts to review and examine detention orders before their execution. Detention orders cannot be challenged at the pre-execution stage on grounds of delay in execution. And such detention orders can be executed anywhere in India, similar to arrest warrants as issued under the provisions of Code of Criminal Procedure 1973. And as regarding the provisions under the Act relating to advisory boards under preventive detention laws, the Act provides the government is required to refer cases of preventive detention to an advisory board within 5 weeks of the date of detention. The advisory board is responsible for reviewing the detention and must provide its reports with 11 weeks of receiving the detention order. If the advisory board is satisfied with the grounds for detention, the detention period can be extended up to 1 year. However, if the advisory board believes there is insufficient cause for detention, the order is revoked and the person is released. And now we would like to discuss some other preventive detention laws enacted by the Parliament of India and which are in operation in India apart from the conservation of foreign exchange and Prevention of Smuggling Activities Act of 1974. The Parliament of India enacted certain preventive detention laws to address various aspects of national security, illegal activities, and public order, and such pieces of legislation enacted by Indian Parliament in regards to such laws in relating to preventive detention are National Security Act of 1980 and Lawful Activities Prevention Act of 1967, then Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act of 1988, also prevention of black marketing and maintenance of supplies of essential commodities act 1980. And besides that, another piece of legislation, that is maintenance of internal security act or MISA, which was enacted in 1971. So these are the preventive detention laws which are in operation in India. So all these acts primarily aims at to establish and maintain national security and to prevent and control all illegal activities relating to India's financial instability or causing any kind of threat to India's security, and also in regards to India's financial position in the world. So the very purpose of the conservation of foreign exchange and prevention of smuggling activities Act of 1974, although still is in operation in spite of India enacted several other pieces of legislation like the Foreign Exchange Management Act of 1999, also Prevention of Money Laundering Act of 2002. And in spite of that, the conservation of foreign exchange and Prevention of Smuggling Activities Act of 1974 is still in operation. And the important aspect of this act is in regards to arrest and detention, and also the very question of detention and the basis of the advisory board and the role played by High Court in regards to judicial review of any such prior detention orders. And also the Act provided regarding detention conditions and about detention orders. So almost we have covered the Conservation of Foreign Exchange, Prevention of Smuggling Act of 1974, and in regards to the provision regarding detention, we have also discussed some other preventive detention laws in operation in India, like the National Security Act of 1980 and also the Unlawful Activities Prevention Act of 1967 and also Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act of 1988 and also Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980. So, hereby we conclude our brief discussion on Conservation of Foreign Exchange and Prevention of Smuggling Activities Act of 1974. And in our next upcoming lecture, we will discuss another piece of legislation relating to financial position or regarding the financial irregularities in India, and that particular act was is the Benami Transaction Act.